our unscheduled post-hearing lawfare lives, what we used to call emergency podcasts, except now we do these on YouTube. I'm Ben Wittes, joining from the Brookings studio, and I see I'm joined by Roger Parloff in the Sconce studio, which is the sconces are not visible, but that's okay because we know the Sconce studio anyway. So yeah, there's the sconce number one, sconce number two. Welcome to all who are joining us. A reminder that our ongoing fundraiser to support the work of Roger Parloff, Anna Bauer, and all the other members of the trial tracking and reporting team is ongoing at givebutter.com/journalism. And for those of you who are, um, uh, uh, there is a link in the chat that you can use for exactly this purpose. Roger, tell us which hearings you just came out of, and what the unifying theme of the hearings, what were they all about? There's this through line between them.
Yes.
It's
Well,
subtle.
this was two of the four law firms that have challenged these executive orders that attack and try to destroy them. It was Perkins Coie at 11 a.m. In front of Judge Beryl Howell, and it was WilmerHale at 2 p.m. in front of Judge Richard Leon. And these were each judge issued a TRO sometime back.
Yeah, let me just pause because this is a very interesting pairing of judges. These judges are both former congressional staffers, as I recall, and both and from opposite parties. So Beryl Howell was a senior Judiciary Committee staffer to Patrick Leahy, and I forget which committee Richard Leon came from, but I'm pretty sure he also came from the Hill, where he was a Republican staffer. Am I remembering that correctly, Roger?
I'm afraid I didn't check that.
I will look it up while you're talking. But I think there's a nice parallelism here. We have two Hill staffers of opposite parties as the relevant district judges.
Yeah, and this is each issued a TRO sometime back, a temporary restraining order. And in these cases, unlike all the other cases, the government is not trying to appeal these as quick as possible to the Supreme Court, probably because they know they will lose at every at every level. So they have not been rushing, and they agreed to keep the TRO in place until what are called dispositive motions can be filed and resolved. And that's what this is for. So this is the plaintiffs in each case have a summary judgment motion, which means there aren't really disputed facts or many. So if the plaintiffs prevail, the defendant, the judge will enter a permanent injunction, and that will be appealable. Meanwhile, the defendants have also filed a motion to dismiss, and that too would be dispositive, of course. So that's where we stand.
Yeah, and just I checked while we were talking, and my memory is correct. Judge Leon was at different times an attorney at Baker and Hostetler and at the Justice Department, but he also served as chief Republican counsel on the Whitewater Committee, on the October Surprise Task Force, and was counsel to the Ethics Reform Task Force. So he had a significant, like Beryl Howell, a significant career in on the Hill, but on the Republican side.
And who appointed him? Was that Bush or?
It was Bush,
Okay,
Bush too.
okay.
Okay, so I think what everyone was expecting, Roger, was that these cases are kind of open and shut on behalf of the plaintiff law firms. Did it go well for them in in both of these courts?
Yes, the plaintiffs, yeah, it went well. The, um, it was, Williams and Conley was a law firm representing Perkins, and a very famous conservative attorney, Paul Clement, of his own firm, Clement and Murphy, representing WilmerHale. And so there was very good lawyering for the plaintiffs. Um, it was a Dane Butts Winkus for Williams and Conley. For the DOJ, it was Richard Lawson, and I don't have his title, but he's a political appointee. He used to uh, work with Pam Bondi at the Florida Attorney General's office. And it was only him at the table. He was all alone. Uh, 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 in the Perkins Coie case, there were 6 Williams and Conley lawyers at the counsel table, 6 more in front of the bar. There were 3 Perkins Coie top attorneys in the well of the courtroom, and actually it was packed, and it was heavily attorneys, maybe from presumably from the other law firm cases that are being attacked, unless it's like Skadden attorneys paying off their indenture, trying to help Trump destroy their competitors. But that didn't seem to be the case.
All right, so let's start with. I take it the earlier hearing of the day was before Judge Howell, and the later one was before Judge Leon. Let's start with the Perkins hearing. Uh,
Yeah.
what happened?
Yeah, of course, she had motions from both sides, and so it was sort of arbitrary who goes first. Usually the moving party goes first. She let the government go first. Um, and he didn't get very far, and before she just was asking him pointed questions, and that continued for about 2 hours, just her asking him questions, and to uh, also set the stage in both of these cases. These uh, all 4 executive orders. I'll step back. There was an early memorandum that attacked Covington and Burling, but it was very narrow. It only took away their security clearances. And they didn't, in fact, it didn't even take everybody's security clearance. It was just those who had worked on who had represented Jack Smith, the special counsel. So it was narrow enough that they didn't challenge. Then there have been 5 more, and Paul Weiss made a deal and got out of it. So the other 4 are going forward. And all of those, there was a TRO immediately entered. But the template that all of these follow post Covington is there are 5 main sections. And the first section is a defamatory section about the firm. It says all the evil things Trump has found you to have done. And then the others are the punishment.
Which in some cases bears very little resemblance to facts, right?
That's right. They are findings that Trump has made. They are not findings that any court has made. They are not findings that any disciplinary body has made. So they are just his. And also they are often findings that are 5 or 10 years in the past from people that no longer work with the firms. And so it's pretty extraordinary because these firms are usually about 2,500 people in size, about 1,200 lawyers, and they're all being punished for something that a guy who hasn't worked there in 10 years allegedly did, but no court has found.
And which may or may not be improper, right?
Right.
So
Right.
one of
In
the
fact,
allegations against one of the firms is that Andrew Weissman used to work there and went on to work for Robert Mueller, all of which is true and none of which is improper.
yeah, and with Wilmer, the main problem seems to be that they welcomed Mueller into the firm after what he had done to Trump, and that they welcomed him with a enthusiastic PR notice talking about all the things that he had done in his career, which is an incredibly impressive career. So no, and in fact with Perkins, one of the main things they're being punished for is election litigation that they won. So by and large. So anyway, that is, and then the second section takes away security clearances. The third threatens to take away contracts, the firm's contracts, but also the firm's clients' contracts with the federal government. The fourth has to do with an EEOC investigation that's going to be sicked on these firms. And the fifth is denies them access to federal, or threatens to deny them of access to federal buildings, and to federal employees are not supposed to engage with anyone in these firms. So the TROs took the section 1, 3, and 5 and barred those, because those are the ones that are the most crippling immediately. So here, there was a lot of discussion of sections 2 and 4, and because those were the ones where the judges hadn't already ruled, and where they were likely to have more trouble. And the security clearances might be the toughest, because there is law saying that the president does have a lot of discretion in granting security clearances. In fact, basically non-reviewable discretion if it's individualized and legitimate. But there is law saying if it's blanket, if it's, and of course, if it's not individualized, if it's some group, that's suspect. And also here, there's a strong argument that it's entirely pretextual. So that's not really, there's no concern here with national security. And in fact, in those section 2s, they don't mention national security. They mention national interest, which is a really fuzzy term. And both judges really focused on that. So we also heard a lot about the other deals that have been made, because, and we know the most about Paul Weiss. It's been sort of fuzzy, the reporting on the other deals. We don't really know if they're written. And Judge Howell asked a lot of questions, but we know a lot about Paul Weiss. We know more because it had already been, there had already been an executive order out against them. There was also an executive order rescinding that executive order. And what you see in there is that all of these punishments were lifted in exchange for $40 million, in legal services, in pro bono legal service. It wasn't in exchange, it wasn't like, oh, we did a vast investigation and satisfied ourselves that you don't present a national security risk. It's 40 million. Okay, that's fine.
Okay, now let me just pause you there, because, when you say imposing these restrictions and then lifting them in exchange for $40 million, that sure sounds like a bribe or an extortion, depending on how you're thinking of it. And I'm wondering, it's really a shakedown situation. And I think a lot of these deals have the quality of, looking like a protection racket. And That's not what the suits are alleging. But if I were a judge hearing what you just described, I would be concerned about the extortion and bribery statutes. And I'm curious whether that came up with Judge Howell.
Judge Howell did use the word shakedown at one point. Um, uh, I'm pretty sure it was Howell and not Judge Leon. Um, Also, the attorney Butswinkus from Williams and Conley representing Perkins, early on he said, I'm not going to criticize the firms that did make deals. And Judge Howell said, you can criticize them. And then he continued and said, so I'm not going to discuss whether those deals violate the law or violate ethical, violation. That was as close as we came. The focus was on mainly the easiest points, which were First Amendment viewpoint retaliation. That's what these are, most of all. Um, Clement did, there's also huge, they're also making due process claims and Sixth Amendment and Fifth Amendment right to counsel claims. Clement did say, although First Amendment is the most obvious and also viewpoint discrimination, the most pernicious is separation of powers. And that's the fact that he's arrogating to himself Article 3 powers, judicial powers. He is declaring who committed wrong, and he is imposing punishments. And he also mentioned that these were, if Congress had done it, it's clearly a bill of attainder. And he actually quoted a Supreme Court case from the I think from like the 1860s, ex parte Garland, I think, but if that rings a bell. But I think there was, I think Congress punished Confederates and said retroactively and said, you can't, I think, practice law. And that was struck down as a bill of attainder. So that's certainly in the air as well.
Interesting. And so, what were the specific concerns that Judge Howell had that didn't come up with Judge Leon, or vice versa, or were the issues essentially congruent?
Well, there was Judge Howell. Like I said, Judge Howell's hearing went on for 2.5 hours. Judge Leon's hearing was maybe about an hour. He said 20 minutes for you, 20 minutes for you, rebuttal. It didn't go that way with Howell, so much more ground was covered. Both did talk about, and I think, both brought up on their own, I think, an important declaration from a man named Leonard. I think it's William Leonard, an initial William Leonard or something. But he was somebody that had been a security expert at the Department of Defense for about 30 years, had stellar credentials, and was saying he had never, ever seen, security clearances stripped in this way in a group fashion, and that doing so did not serve national security. In fact, it hampered national security. To get a security clearance, you go through a very individualized process, 13 steps, and so to have an entire firm, included down to the mail room, stripped of these is totally unheard of. And it included in, I think, Perkins' case, Perkins had about 24 people with them, including around 12 that didn't use them for the firm. They had them from their military background. and some were still in military reserve. And so this was punishing them and punishing the country um, uh, uh, because of, this vendetta that.
So tell us about the government's arguments
Yeah.
here. What's the case that this stuff is kosher? And specifically, does the government even purport, given the given the paragraphs that lead these executive orders, which are like by their terms overtly retaliatory, does the government even claim that this is not retaliatory based on viewpoint discrimination and based on, client representations by these firms? What does, the Justice Department contend the executive branch is doing here?
It does contest it. None of the judges were buying it. They have both, and I think all four, in fact, have said, it's retaliatory on its face. But what he tries to do is he kept trying to go, let's look at it from the 30,000 foot level. Let's look at, and he kept trying to also look at each section as like it was divorced from every other section, and to say, well, the first section is just the president's free speech. He gets to voice his opinion, as if it has nothing to do with the other four. And then the others are, well, these are all executive discretion. The executive has great discretion over security clearances. It has discretion over contracts. It has discretion over who it lets into buildings. I don't know. I don't know.
So that may be the best that he can do, given a really bad set of facts.
Yeah.
But I want to suggest that, so if you, and this gets into how one parses an executive order. Sorry, go ahead.
I guess the real answer to the Section 5, which is the barring people from buildings, is he's saying, well, that hasn't happened yet. Of course, it has happened, but he's saying, no, the agency heads will have to issue guidance. And until they issue guidance, it's not ripe. So we don't know how they'll interpret this.
So let's leave that one.
Incidentally, what Judge Leon said was, so when a client comes in and says, but I read you aren't going to have access to these buildings, you're supposed to tell them, oh, but there hasn't been any guidance yet. Maybe we'll get a chance to go into the buildings. Maybe we'll still be able to go to court. So I don't think he was buying the idea that this isn't ripe.
Okay, so
and the other,
I'm confused about a little bit about the hacking off of the first section from the second and third and fourth sections, because it is true that the operative language is not in these defamatory paragraphs up front. But if you are saying, well, the president has a lot of discretion on these other things, except perhaps with reference to security clearances, the discretion isn't unlimited. And you evaluate whether something's a reasonable exercise of discretion in large measure because of why somebody says they're doing it, which is the purpose of that prefatory paragraph up front. And so if you say, well, we're not going to consider what that means and why they say they're doing it, you're left with a weird situation where you have no stated rationale for these punitive actions against people. You shouldn't be able to win on that basis either. Like, I'm going to cut your head off and not say any reason for it is no more of a winning argument, at least I would think, from I'm going to cut your head off because, here are some made up facts about you.
Yeah, and that's what the judges were saying. Um, and for all of these, the way they're phrased, the agency is supposed to review your access to its buildings in light of the first paragraph. And in some cases, like Section 4 about the EEOC is supposed to do an investigation of you. Well, Section 1 says you're discriminating on the basis of race. The finding comes before the investigation. And then the chief of EEOC is supposed to do an investigation. The president has already told him what to find. So, no, it's very hard, and it did not sound like uh, anyone. There was some argument about, well, are any of these things severable? Like in a contract that has several provisions, one provision might be, or in a statute, one provision might be unconstitutional, and you decide whether it can be separated out or whether it's too much of an integrated whole. And I think the the plaintiff's lawyers seem to be making headway that this was an integrated whole.
So, do you have any doubt in your mind that both of these firms, from these two judges of uh, rather diverse politics, are going to get their permanent injunctions in relative short order?
Well, I think they're going to get them. I'm pretty confident. I think that Judge Howells may come down before Judge Leon's. He said at the end, and Judge Leon has a soft voice, and my ears aren't that great. But the guy next to me told me, he said it might take weeks. Um, and like I said, the government isn't pushing these because it knows it will lose, and also because there's a lot it can do regardless of loss. Um, Being on an enemies list of the president is a bad thing, as 60 Minutes is finding out right now. There's a lot that a lot of abuses of power that can take place in ways that are hard to prove.
Right. So we're going to turn to that in a minute, but I want to exhaust the actual before we get to the extra legal process of retaliation against law firms. Let's follow the legal process to its conclusion. So let's assume that in the next 3 weeks you get a permanent injunction in one or the other or both of these cases. The government has not appealed either the TROs or the preliminary injunctions in any of.
There
Is that
was no preliminary because they agreed to, will extend the TRO until this dispositive hearing.
right? But okay, so
Yeah.
unlike other situations in which we found out in these last 3 months that actually, contrary to everything we thought we knew, TROs are actually appealable. At least if it's not clear when TROs are appealable, but when the Trump administration appeals them, they appear to be appealable sometimes. And they've been pretty aggressive about appealing them. And now they're going, but this one they did not appeal. In fact, they, as you said, jointly agreed to extend it, which I took to be a pretty substantial acknowledgement that they're not looking to push to the Supreme Court this particular question with as much alacrity as they are, say, some other questions that they may expect to do a little better on. Do you think there will be an appeal of a injunction, or do you think they will say, okay, we're not going to get any better, we're not going to do any better on this with the DC Circuit or the Supreme Court, so we may as well rely on the extra legal pressures that we can exert rather than trying to bring this to a higher level and getting binding precedent that is going to be injurious to us?
It's a good question. I don't know how they're going to resolve that. It's going to look pretty bad if they don't appeal. Um, Maybe if they appeal, but let it, but not on an expedited basis, let it just sort of fester. That might be the best thing they can do. So let it go on for months and months as if it's not finally decided. And that I think with $1 billion of settlements so far, they might not need to do too many more of these. I think they've met their goal. Um, so I think that I would slow walk it. Do an appeal, but slow walk it. If I could mention one non sequitur, but I want to make sure I don't forget it, and I will forget it if I don't grab at it. Um, One thing that came up at both hearings, and that Judge Howell particularly asked about, you remember early on, I think we've discussed several times that on our regular, like Fridays, that when these TROs are issued, the defendants have to issue have to issue status reports. Are they complying? So they're supposed to notify, all the agency heads that there's a TRO, and even though they sent out notices before to screw all these law firm people, um, that's rescinded now. And if you remember, a couple of them have been very, I thought, nearly contemptuous. One of them, for instance, says what they're supposed to say, and then this was one of the early ones in Perkins. The executive branch position is that the executive order is permissible and that the court's order was erroneous. So far, so good. That's probably not too offensive. Then it says, the government reserves the right to take all necessary and legal actions in response to the, quote, dishonest and dangerous, unquote, conduct of Perkins Coie as set forth in Executive Order 14230. And her order had banned or had barred Section 1, 3, and 5. Section 1 is the one that contains this defamatory language about the dishonest and dangerous conduct. And so she asked quite a number of questions of uh, Lawson, the DOJ lawyer, about that. I said, was that really necessary to fulfilling my order? And he said, well, it wasn't necessary, but I think it was within the prerogative. And did you write that? And he said, well, I was certainly aware of it. By the way, I should also say that there were a tremendous number of questions that Lawson was unable to answer. She asked a lot of questions about the other deals. Are they written down? I don't know. I didn't realize that was. Don't you think the context is relevant to? I mean, the context was discussed in the plaintiff's papers. Well, I don't know the answer, and a lot of questions about the other deals and their terms.
Yeah, so that brings me to an interesting question. Formally, if you declare one of these things invalid, you take away the executive's ability to issue more of them, at least in the sense that, well, they can issue them, but they can't enforce them, right? Particularly if the DC Circuit affirms. That said, it doesn't formally prevent the executive branch from doing it. which is why we still have a whole lot of racial exclusionary covenants in lots of people's real estate transactions. They're unenforceable, but people, don't notice them and therefore don't bother to take them out, for example. Um, and so my question is, first of all, do the other deals stand if the only leverage that Trump has to enforce them is to, if you don't honor the deal, you're gonna get executive ordered, and you can't issue the executive order. What prevents other firms from walking away from their deals at this point?
Well, until there's a final, ruling from the Supreme Court, I think they have to, I guess, I mean, I think you're right that these things were never going to be enforceable in a court of law. They're void as against public policy. But what makes, they're worried about what's happening under the table. They're worried about when our clients need to do a merger, are you going to block it just because we're on your enemies list? And as long as they're pleasing Trump with these deals, they're okay with it. If Trump starts making demands that they really can't live with, then I don't know what happens.
Right. So that brings us to the thing that holds this whole thing together for the president, which has nothing to do with law, and everything to do with the White House's ability to intimidate people extra legally in exactly the way you describe. And the reason there are these deals, even though everybody knows that that these EOs are not going to stand up, is because if you want to get a meeting with the Deputy Attorney General's office before your white collar client is indicted, you better not be from Wilmer or Perkins or one of the other firms that is in this position now. If you want to, get a merger approved. And so my question is, was there any talk about how do you monitor compliance with this?
Only a little indirect. One of the ways that another way that Lawson was trying to defend these things is that every once in a while in the section, the section will say something to the effect like, agency heads must refuse to engage with every single employee of this firm to the extent permitted by law. It'll have a little phrase like that. And so Judge Howell was saying, well, suppose I give a declaratory judgment that these are root and branch unconstitutional, then all of those little phrases, where to the extent this is permissible by law, would take effect, and the whole thing, I don't even have to issue an injunction, do I? And she was looking at it in the perspective, to issue an injunction, you need to go through 4 factors, you need to prove irreparable harm and this and that and that. And she was saying, maybe I don't have to go through that. And but Swinkus for Perkins said, that's a very good point, and I hadn't thought of that. And but you should, in addition, do the injunction, because if there are enforcement issues, we want to be able to come right back to you.
Yeah, that's
So
interesting. I mean, my guess is there's going to be a million enforcement questions, and a lot of them are ones that are going to be actually hard to bring to a court because you you want a meeting with X office and you don't get one.
yeah,
And you have no way to know, did I not get one? I have the general impression that this is the sort of meeting that I used to get. And it's the sort of meeting that if I were the assistant deputy treasury counsel for blah, 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 I would give me. But you really don't know if that meeting doesn't happen because that person is, out sick, or if it's, that New Yorker cartoon where the guy says, no, Thursday doesn't work. How about never? Does never work for you? There's this EO that says I'm never supposed to meet with you. You just don't know why people are doing things like that. And, the blacklist can work without ever anybody getting an instruction, don't do business with Roger Parloff. Just everybody knows Roger Parloff is on the blacklist.
because, and that's right, and it's because 9/10 of the power of this is not direct uh, punishment of the firm, it's punishment of their clients. And so it's the clients that are going to say, really, do I want to choose Perkins when I could just choose somebody that doesn't have this problem? And then I won't have to worry, is that, uh, this is a criminal investigation. I can't risk being, hiring the firm in the doghouse. And almost anyone who goes to these firms, it's a make or break situation. And so it's really, that's why the nine have caved. It's just devastating in terms of clients.
All right. Is there anything else we should cover before we wrap up?
I think that's pretty good. I'm sure if I poured through my notes, I'd find some, but I think those are the highlights.
All right. Roger Parloff, thank you for joining us today. Thanks to everybody who joined us for this. We're going to need a special, like maybe emergency Lawfare Live or Lawfare Live Unplanned. I need to come up with a good name for Lawfare Live Spontaneous. I'm not sure. We're going to work on that. If you guys have suggestions, leave them in the chat. But thank you for whatever kind of Lawfare Live it is. Thank you all for joining us. And we'll be back. We'll be for our regular time on Friday, but we'll also, I'm sure, there may be other situations that arise.